Ajmair book Civil Passage number 26 recorded by B&A Shorthand Studio, dictation speed 100 words per minute, ready, start. Through this writ petition, petitioner has challenged the judgment order dated 13th April 2007 passed by learned additional district judge Khushab, whereby the revision petition filed by him was dismissed and the judgment and decree dated 22nd February 2007 passed by learned senior civil judge Khushab, whereby the suit filed under section 9 of the Specific Relief Act, 1877 by respondent number 1 plaintiff was decreed para briefly, the facts of the case are that on 23rd August 2001, the plaintiff respondent number 1 filed a suit for repossession of plot nearing one canal specifically mentioned in the head note of the plaint. The written statement was filed and suit was contested. Learned trial court framed issues and invited the parties to produce their respective evidence. Both the parties produced oral as well as documentary evidence in support of their versions. After the closing of trial, wide judgment and decree dated 22nd February 2007, suit was decreed by the learned trial court. A revision was filed, which was dismissed. Wide judgment dated 13th April 2007. Hence, this writ petition by the petitioner defendant, learned counsel for the petitioner defendant argues that the original gift deed on the basis of which respondent plaintiff claims ownership of plot has not been produced, that it has never been proved by the plaintiff by producing convincing and confidence inspiring evidence that she was in possession of suit plot, and when she was dispossessed on the specific date by the petitioner defendant, that none of the ingredients required to be proved for prayer of relief under section 9 of the Specific Relief Act is available, nor same has been proved. Further argues that learned courts below have mainly relied upon the proceedings of a criminal case registered against the petitioner with regard to the same alleged occurrence of taking over the possession of plot in dispute, therefore, praise that the order, the impugned judgment and decree passed by both the courts below be set aside and suit filed by the plaintiff respondent be dismissed. Learned counsel for the petitioner further argues that when the suit for declaration under section 42 of the Specific Relief Act filed by the petitioner was pending and learned additional district judge had also passed an order for proceedings simultaneously in a court, therefore, that suit should have to be decided with the suit in hand. Para. On the other hand, learned counsel for the respondent number 1 plaintiff argues that there are concurrent findings of facts recorded by two courts below and there is no defect in the same by referring the oral as well as documentary evidence, that the plaintiff respondent has fully proved that she was in possession of suit plot on 24th February 2001 when she was dispossessed without her consent by the petitioner defendant, that the criminal proceedings is relevant, and further that when petitioner defendant while appearing as his own witness has admitted that on the gift deed fingerprint expert has reported that his thumb impression are available, therefore, that evidence was admissible as has rightly been relied upon the courts below. I have heard the learner counsel for the parties at full length and also gone through the voluminous record appended with this writ petition as well as produced before the trial court in shape of documentary evidence. Full stop. Stop writing please.